The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear this morning is Trimble versus Entrada, and Ms. Santos.
Thank you, Your Honor. May it please the court. My name is Jamie Santos, and I represent the appellant, Entrada, which runs Resident Portal. Resident Portal is a website and app that allows apartment tenants to communicate with their leasing office, submit maintenance requests, make online payments, or engage with their housing community. Ms. Trimble sued Entrada, claiming that Entrada unlawfully charged her a convenience fee when she decided to pay her rent on Resident Portal rather than giving a check to her landlord. Resident Portal, like most apps, is governed by terms of use, and Section 14 of the terms is an arbitration clause that binds both Entrada and tenants to arbitrate any dispute arising out of tenants' use of the website. And the question here is whether that mutual agreement to arbitrate is rendered illusory by the fact that Section 3 of the terms says that the agreement may change from time to time. The answer to that question is no. Maryland law is clear.
May change from time to time sounds pretty illusory.
Well, Your Honor, I think Maryland law is clear that an illusory promise is one in which there is no limitation whatsoever on the promisor's ability to renege on his past promise. And here, if you read the terms...
To me, you can change it without notice at any time and then go and assert a claim, and your counterpart would never have seen it.
I don't think that's right, Your Honor.
And I thought your argument was that you have a mechanism for seeing it, but it seems to me we have said pretty clearly that if you have a unilateral right to change the terms of the agreement without notice, that's illusory.
Well, Your Honor, I think there are two things in this contract that make it particularly non-illusory. The first is that it's not retroactive. So the cases like Johnson and Cody and
Well, how do
Cheek...
you know? It can be made retroactive, whatever term you want.
Well, Your Honor,
Entrada could say, we're now going to change this, and as a matter of fact, we're going to say from January 1, but that's not the real problem. The real problem is whether you agreed to anything, whether the other side agreed to anything.
Well, Your Honor, I think if you look at the first sentence of Section 3, which is the change clause, it says that the tenant's bound by the agreement that's in effect on the date of their visit. And so even if Entrada goes and makes a change and, completely eliminates the arbitration clause, that would apply going forward, but it wouldn't be retroactive. And then I think the second part that is a very clear limitation...
I understand that. On April 1st, you change it, and the client goes in on April 5th and didn't know it was changed and is now bound by it.
Your Honor, the client would not be bound by something...
Why not? Because you made the change April 1st.
Because, Your Honor, there's two things. So first, with transactions, Section 1 of the terms is very clear that for transactions that are conducted on Resident Portal, and that's the entirety of the claims here, they're only about transactions, a tenant has to agree to the terms every single time they engage in a transaction. And so they have to click.
I understand, but when they go on to engage in that transaction, you made a change 5 days before that they didn't know about. So they're agreeing something they didn't know about.
Your Honor, that's not right, because you have to, every time you engage in the transaction, you have to agree to the terms that are then in effect. You are not bound.
I know, but you agree to terms, but the point is that every time you go in, you're asking the client to compare those terms and conditions with the last month. Every month, you want them to go there, compare the conditions, and see if they've changed.
Well, Your Honor, there's...
And those terms and conditions, if you've read them as a practical matter, no one can compare the terms and conditions from last month. They're not even online anymore because you've changed them. So how are they going to know what has been changed?
There's no case that the other side has cited, and I have not found any case that says that you have to provide a red line for a contract not to be illusory.
You have to provide notice to have an agreement.
Exactly, Your Honor.
In order to be any kind of an agreement, there has to be a consent. And to have consent, there's got to be notice. And you can't just spring it on them and say, oh, you go into the transaction, and incidentally, we made a huge change there, and the client has to go, and under your terms, has to go and compare the current terms with the last terms without any notice at all.
Well, Your Honor, that's to make 2 points. The first is that, so Johnson and Cody said that notice and an opportunity to cancel would be sufficient to render a promise not illusory, but it didn't say that was a necessary condition, nor
How
could
do you
it.
have consent without notice?
Because every time someone engaged in an online transaction, every time they had to agree to the terms that were in effect. So they received notice, they had to click consent,
They didn't
and
have notice of the change.
Well, but Your Honor, they had notice of what the terms were, which means that they could not have been, unilateral.
That's pragmatically pretty tough when you have a monthly payment. You're paying rent every month, right, through this portal.
Yes.
And so it's an ongoing thing. So every month you click and pay it. Now, you're asking the client to go click and go read the terms and conditions to make sure there's been no change before they can agree to it.
No, Your Honor.
And because you have reserved the right to make a change at any time without notice.
Your Honor, we're not asking the client to go and compare.
For an agreement.
We're asking the client to confirm or to explicitly assent to the terms that are in effect. So, and the Section 1 specifically says that a tenant has the right to not conduct electronic transactions in the future. They can always go and pay their.
What's the problem with putting a clause in there and saying, from time to time, we'll make a change and provide you notice, and if you continue to use our card after we receive our notice, you'll be bound.
Well, Your Honor, I think that that's what
What's
Section.
wrong with that?
Nothing's wrong with that. I think that is exactly what Section 1 does for transactions. It says every time you engage in an online transaction, you have to assent to the
But you don't
terms.
provide notice of changes.
Your Honor, so there are cases that have
Forget the
that.
cases, just tell me that as a matter of agreement, I mean, we're talking about contract law where two people come to agree and consent to some kind of a course. We're not have a gotcha arrangement. What you need is an arrangement where two people consent knowingly. And you've got a clause in here that says we can change it at any time without notice. And the question is, oh, you've got notice because you're told every time you use this, you're subject to the terms and conditions in effect at that point. That's your argument.
No, Your Honor, my argument is that the clause says the terms may change from time to time. Every time someone engages in an online transaction, they have to specifically assent to the terms that are in effect then. They have an option, and they are told specifically in Section 1, you can always decline to participate in an online transaction.
It's an impractical matter to read the terms and conditions every single month. It may take them an hour to do that, more. The idea, every month, you have a month-to-month portal payment, and you charge a fee for that. And they go and pay month to month. And you say, we can change the terms anytime without notice. You don't notify them. And then you got the situation where you have now, and you say, oh, we got an agreement, you agreed to it, because you didn't read every month the terms and conditions.
But, Your Honor, the law of illusory contracts in Maryland doesn't look at general kind of principles of unconscionability. Is
It
this the most fair thing?
requires
No, Your Honor. The law of illusory contracts in Maryland, and this is described in Cheek, in Questar Builders, in all of the cases that we cite, it says that for a promise to not be illusory, there has to be some limitation, any limitation whatsoever, on the promisor's ability to renege. And having to have somebody consent to the terms each time is a limitation. If Ms. Trimble went into arbitration, demanded arbitration now, and asked to arbitrate the payments that she made in 2023 and 2024, there is absolutely nothing Entrada could do to renege and avoid arbitration. It is bound by the agreements that she signed on those dates of those transactions. So I think, Your Honor, I take your point that you see, these terms of use documents generally as unfair or one-sided, but that is not what the law of illusory promises looks at in Maryland. And there are also two really important principles of Maryland law that I think the district court didn't consider. The first is that Maryland law favors non-illusory readings of contracts. That's a kind of first order principle of Maryland law. The second is that and this was discussed in Questar Builders, the implied covenant of good faith and fair dealing can supply an implicit limitation. So if Your Honor is worried about, this seems kind of one-sided, the implied covenant would require Entrada to exercise its discretion in good faith and fairly. And it would require, for example, for transactions to provide notice and the opportunity to consent, which is exactly what this agreement provides. I really think, and I understand that, Johnson and my friend has argued that the implied covenant and these kind of principles, the canon against illusory readings of contracts, they don't apply because they weren't part of Cody and Johnson. But Cody and Johnson were looking at very different questions. Cody was looking specifically, everyone agreed that the language in Cody created an illusory contract. The only question was whether that clause applied to the arbitration provision at issue. And in Johnson and the cases that followed, the only question was whether the change clause was, it was illusory, but was it saved by this kind of generic notice as provided by law question? And it wasn't. And those cases, did not discuss the implied covenant because it wasn't raised and because the language of those agreements were absolute, detailed, and unyielding. Our case has general language, much like the language used in Questar Builders and in the Jukebox Merit Music Systems case. It's general. It just says the terms may change from time to time. There's nothing that would be at odds with that type of language to see these limitations requiring affirmative consent each time. And in those cases, they had language like the absolute sole discretion can make any change at any time with or without notice, and those changes apply retroactively. There is no language like that in this contract. And so I think this falls squarely within the restatement, within the Questar Builders case, and within all of the other cases that recognize that if there's some limit on Entrada's ability to just pull out of arbitration after arbitration is filed, then it's not illusory, and those limits exist here.
So are we to understand Section 3 as meaning that each time a client uses the site or engages in a transaction on the site, there's a new contract? It says you're bound by the version of the agreement that's in effect on the date of your visit. So if she visits the site on June 1st to pay her rent, she's bound by, and Entrada's bound by, the version on June 1st, and that version cannot be changed at any point in the future. And then if she visits again on July 1st to pay her rent, and there's a new version, both she and Entrada are bound by that version, which cannot be changed for purposes of that transaction, even though if she visits in the future, there might be a different version. It seems to me the suggestion here is that there's multiple, it's a different contract every transaction. And if she sues then about June and July, there might be different contracts that govern those transactions. Is that correct?
That's exactly right, Your Honor. I think that's clear from the language of Section 3, the first sentence, but also from Section 1, which governs online transactions in particular. It says, you are agreeing to the terms in effect by, signing and clicking on the I agree to the terms and conditions box. And I think the reason why, unlike the kind of employment contracts and credit card contracts cases where there really is a continued contractual relationship that you actually have to cancel, going to a website like Entrada is like going to a store or going to a restaurant. Every time you go, it's a different encounter. You might have, different terms, different prices, and a different agreement.
Is there an application form that you have to
No.
sign when you enter in?
No, I mean, you can create
When you start with Entrada to pay your monthly rent, what do you have to supply? You have to supply, obviously you have to supply the mortgagee's name, address, the amount, and so forth, don't you?
So when you can create a username and a password to go onto Entrada, because you can do all kinds of things on Entrada.
Do you give it an account number?
I don't think it has an account number. No, it's just like if you're going on to Nordstrom.com and you're like buying something.
I'm trying to find out when you start with Entrada and I want you to pay my monthly rent. You're saying there's no document I have to fill out that creates an account?
Well, so there's no subscription service, right? Like I am subscribing to Entrada for this year and it costs X amount per month. You have an online account, meaning that you have a username and a password, and then you can go on each month and you can pay electronically, or you can choose to just go give your landlord a check or mail a check. But it's not this kind of continuing contract. And I think
So it's like a bill pay It's a bill pay portal. I assume the
Exactly.
relationship is between Entrada and the landlord.
Exactly.
Right.
The continuing relationship is between the landlord and the tenant, and then between Entrada and the landlord. They'll decide whether to make the service available. But that's, I think, a really key distinction. It's not this ongoing relationship. And I think it makes a ton of sense that you have, I mean, these terms of use documents that say we may change this from time to time. They're not just normal, but they're necessary, because when you have companies like Entrada that changes its product lines, there are regulatory changes, legal changes. It actually
Well,
has to
those
change.
changes may be necessary, but my question is, I understand your argument, and it sounds to me highly technical, but what you're expecting of the client is that every time you pay a bill, you expect them to continue paying the bill from month to month. You get a fee for that, and they expect to have that convenience from month to month to have that bill paid. So they go online and click and say, pay it. And what happens is you don't tell them that from the last time you paid, we've changed our bill. Notice new terms or something like that. You don't put that in there. So there's a little bit of a gotcha, not technically, because you point out that every time they have a transaction, they agree to the transaction as of that moment. But that transaction could have changed many times before the next transaction. And the common sense approach when somebody pays a bill from month to month, a rental bill, they don't want to have to send it in themselves. They have your portal take care of it for them. And yet you now want them to go through the practice of reading the entire terms and conditions to see if they agree with them every time they pay. And that's got a gotcha aspect when you don't provide notice of the change.
Your Honor, may I answer? I see my red
Oh,
light's on.
please do.
Thank you, Judge Niemeyer. So I think we expect that what they will do, they assent affirmatively through a click, I agree to the terms and conditions.
I understand
Yes.
that. Yeah, I
And so-
understand all the terms.
Yeah.
I'm talking about this pragmatic aspect where people, how people agree to things. And you're suggesting that every time they go online on a month-to-month, they're going to pay this rent every month. And every time they go on, they have to read the entire terms and conditions under the contract that you've provided. You said, we can change it any time, just make sure you check. And so you provide a service, and then they have to read how many pages of those terms and conditions? They're pretty tough, right?
Yep, they're pretty long, Your Honor, and I don't doubt that. And I'm not disputing that. I think our point is that because the law of illusory contracts doesn't look to kind of general one-sidedness or burden or, is this going to be difficult? It looks to
Well,
whether
this
there's
is
a limit.
formative area. This, Johnson was a case, I was on the Johnson case.
Yes, Your Honor.
And these cases are all a little difficult because online transactions are becoming more and more regular. And if we're going to have agreements connected with them, it seems to me we have to have some criteria as to how the meeting of the minds comes about. And I'm not sure all the inputs. This raises another twist, which is you require a new contract with respect to every transaction every month. You say, when you sign this one, read the terms and conditions. They may have changed, but you never notify them of the change, yet you provide a service which is an ongoing service. You say, no, it's not an ongoing service. It's like going 1 month to Home Depot and buying fertilizer. I mean, it's not that. It's a month-to-month in a consumer's mind. It's a month-to-month payment of rent. And you're saying they have to go in and read the terms and conditions because technically that's what we told them to do. But do you think they understood that when there's been no notice of a change? Pragmatically, you're asking a lot, I think.
Well, if I can provide any reassurance to you, Judge Niemeyer, I think it's this. I think the cases where this court and the Maryland courts have been the most concerned is when you have these clauses, like in Johnson, that says we have a unilateral power to make any change we want at any time without providing you notice. The second we decide to make a change, it automatically becomes effective. And then the clause in Johnson specifically says, At our option, we can apply this change back to your prior transactions, to the beginning of the contractual relationship. I think this case is so much easier and less concerning because there's a different transaction every time, because there's consent that's required every time, and so you can't have a situation where there is no meeting of the minds. It may be that tenants decide not to read the terms, but they're expressly consenting that they did and that they understand them. And so I think the situation that you're positing kind of assumes that tenants are being, not truthful when they're expressly clicking the terms and conditions, that they understand it, and they always have the option to pay rent, how I did my whole life, just by writing a
Yeah,
check.
we got a red light, so you got
Thank you, Your
some
Honor.
rebuttal time coming.
Thank
And,
you.
All right. Why don't we hear from Mr. Carney?
Good morning, Your Honors. May it please the court. The district court's decision below should be affirmed. Judge Bennett denied Entrada's attempt to compel arbitration here and to force the plaintiff to travel to Utah, the consumer plaintiff to travel to Utah to arbitrate in front of a commercial attorney.
Well, that's not at issue here. What's at issue here is whether this clause is illusory. And Entrada's position is it's not illusory because there is a new contract formed every time you go online. It's not an ongoing thing. And technically, it seems to me, the arrangement seems to be that you go on with a single transaction to pay rent, and it says, look at our terms and conditions. You have to click through to see it. So there's no issue about whether it's a voluntary click. You have to go through the terms and conditions. The question is, in my mind, is how do you get the term, this agreement may be changed from time to time, how does that become illusory when the transaction that you're engaging in is already fixed?
Well, Your Honor, first of all, the transaction that they're engaging in is not necessarily fixed. It is, in fact, an ongoing relationship.
Well, how do you establish that? What establishes that?
Well, Your Honor, there's a requirement in the contract, in the terms, that the resident that's paying rent check the site for notices. And notices are defined to include things like subpoenas and legal process. They say that if a notice is posted on the website, the consumer is deemed to have received it. And in fact, the terms require the consumer to visit the website. The terms say you must check the website for notices.
Are the websites unique to each customer?
No, Your Honor. This is a terms that apply
Is
to
the customer
everybody.
given an account number, or when you sign up with Entrada, is it a single transaction by single transaction, or is it an ongoing arrangement?
Well, Your Honor, like you observed, this is an ongoing arrangement. This is the payment of rent.
Well, I observed it non-critically.
Yeah, yes, Your Honor.
The question is, legally, is it an ongoing arrangement? Do they get an account number assigned to them?
I don't believe that there is anything in the record that talks about that, Your Honor. And I don't think there's
Is there
anything in the
a-
record that speaks to the other facts that my learned counsel on the other side talked about.
Is there anything in the record about how the plaintiff paid her rent between, the complaint talks about payments in maybe July and August of 2023, and then February of 2024? I didn't see anything about this sort of ongoing relationship of, every month, I'm going to pay my rent, and in addition to that, that it's a ongoing relationship established by a contract.
Well, Your Honor, if you look at Joint Appendix 66, for example, or I'm sorry, yes, Joint Appendix 66. At footnote 6, this is Entrada's motion to compel arbitration. And they list out the payment dates, and there's repeated payment dates. And those are all prior to October 2024. So this is the list of all of the times, all of the subject transactions.
Yeah, it's just, there's kind of a factual problem and a legal problem the legal problem is more important, right? Does the contract create a continuing relationship, or is it, a new contract for every transaction? And then you have a factual problem that if you're going to hypothesize a continuing relationship based on the idea that someone pays their rent every month through this portal, she didn't pay her rent every month through this portal. There's a
Correct.
gap between August and February, right? So-
Yes, Your Honor. But there is the
So she wasn't
requirement-
required to use this site. She could pay it other ways.
I don't think that there is anything in the records showing that she's required to use the site to pay the rent. But there is the.
She didn't breach the contract by not paying her rent through this site in December.
No, Your Honor. No, Your Honor. But there is the requirement to check the site for notices.
Yeah, because that's where the notices are. It's like saying, read the newspaper if you want to know about real estate transactions.
In a way, but the newspaper, for example, has a date on it, and it has, specific, it has the date. And there's nothing in the changes that Entrada provided on the terms that has a date. There's nothing even that suggests that the terms changed. There's no version
Well, that's because
date.
it's a new contract, right? Every time a consumer enters a contract, we expect them to read it, or we pretend like they read it, right? It's a new contract. It's not, why would they have to say, here's all the changes we made since the last version of this contract we created?
Well, because again, Your Honor, they require Ms. Trimble to visit the site. So it's not just it's not just the payment. The contract is not just the payment. The contract also includes the obligation of Ms. Trimble to check the site for notices in the future.
How do they
And-
enforce that obligation?
How did they enforce the obligation?
Yeah, you're hypothesizing that there's an ongoing obligation to regularly visit this website, and if she doesn't, what happens?
Well, then she breaches the contract. And the
Really?
contract.
Where's that?
Well,
Is there a
the-
breach clause that tells me that if you don't visit the website, it's a breach?
Well, it's just, Your Honor, just based on the fact that the contract says you must visit the site to check for notices. And so by not doing that, that's violating that specific term. But the thing is that if we look at these rental payments, and they all predate October 2024, and then if we go to JA 64, which is a couple of pages earlier in their motion to compel arbitration, the terms that they cite post-date all of the transactions in the record. So this idea that the contract or the terms that they're focusing on are the terms for each payment doesn't jive with what they told the district court. They cited the October 16, 2024 version of the terms to support their motion when that postdates all of the transactions in the record. And so it just doesn't make any sense that this is their argument that this is a one-time deal, that just paying the rent and the contract is over. Because what they're trying to do is impose the terms in the October 2024 agreement to all of the prior transactions. So yeah, that also undermines the
You
argument
should
that
be
it's.
focusing in response to Judge Rushing's questions. You should be focusing on the agreement, and there are suggestions in the agreement that this is an ongoing subscription. They talk about all this, they talk about licensing, they talk about ongoing transactions, they talk about ongoing services, and those types of things. It seems to be something you should have focused on if you're going to establish an ongoing relationship.
Yes, Your Honor, and this is absolutely true. For example, in section 15.5, there's requests to change personally identifiable information, which suggests an ongoing contract.
But what about the contract suggests that changes would be retroactive?
Well, again, Your Honor, the fact that Entrada used the October 2024
No,
term.
but that might have been wrong. They may have been wrong to do so. What about the contract lets them make retroactive changes?
Well, there's nothing in the contract that prohibits retroactive changes, and so.
Is there anything that allows retroactive changes?
Yes, Your Honor. The clause that says that the agreement may change from time to time. So,
Well, that doesn't say that it's retroactive or when it applies. It says you're bound by the version that's in effect on the date you visit.
yes, Your Honor.
We may change it in the future.
Well,
And then
but it
you'll be
doesn't
bound
say
by,
that.
then you'll be bound by the version that's in effect on the date you visit in the future.
And if it had said that, that might be slightly different, but as Your
I think-
Honor.
I think I
mean-
read it. You're bound by the version of the agreement that's in effect on the date of your visit.
Yes, but it doesn't say that in the future, I mean.
Did I misunderstand you earlier? Didn't you say that appellee is trying to impose terms that post-date the payments?
Yes, Your Honor.
So that itself is an example of they are applying it retroactively.
Correct, Your
Right?
Honor.
Okay.
Yes. Yes, Your Honor. And so, just to turn back to Judge Russing's question, the fact that they can change the agreement from time to time means that they could change the agreement to include retroactive changes. Like we were just discussing, the
are.
fact that and this illustrates, it's not, they
Right.
could be wrong,
I
but
mean,
it's illustrating the
Not
the
to,
problem.
not to stick to the contract, but, and then for all future transactions, they could make retroactive changes.
In all future transactions.
Right, yeah, but that, changing it to be able to make retroactive changes still doesn't say, as of today, our changes are retroactive, right? They still can't touch the version that was in effect last year because that version didn't allow them to make retroactive changes. See what I mean? It's a prospective retroactive clause.
I understand your point, I think, Your Honor. I mean, it's very confusing because, especially the way that Entrada has employed this, because, number one, they can change it at any time. The clause says the agreement may change from time to time, and you're bound by the version that's in effect on the date of your visit. And so that's kind of like, I mean, there is a little bit of a tension between those two statements. It's like with one hand giving, the other hand takes away. And at best, I think that creates an ambiguity. And under the Dumais case and the Cheeks adoption of Dumais, any ambiguity goes against the drafter of the arbitration agreement.
When it comes to the course of conduct, you haven't made an argument that this agreement, that we should look outside the four corners, right, and interpret it based on what Entrada has, what they've actually done, right? You were pointing out that, they're trying to enforce something retroactively, but you haven't argued we should use a course of conduct to interpret the agreement, have you?
No, Your Honor.
Okay.
It just is an illustration.
Gotcha.
It just illustrates the problem. The other issue, I think, that remains, even if this is not an illusory unilateral change clause, even assuming that the change clause is not illusory, there's still the remaining problem that Entrada removed any opportunity for Ms. Trimble to require arbitration. The contract says that any claims, including under the law of contract, are waived. And of course, the only way to compel arbitration is to file a claim. That's what we have here. Entrada filed a claim to compel Ms. Trimble to arbitrate. Now, of course, Entrada did not waive any of its claims, but these terms purport to waive any claim of any sort by Ms. Trimble, which means that she couldn't require them to arbitrate. She couldn't file a claim to
With that
compel
provision,
arbitration.
and I know the district court didn't decide this issue, I found it tricky because there's a severability clause, but the severability clause seems to suggest not just that you sever, but that you add, in place of what was severed, you're adding terms that from other agreements. I didn't see much argument by the parties on severability, but what's your position on that clause?
Thank you, Judge Russi. My position is that that's really a rewrite the contract clause. It's not a
Yeah.
severability clause. It says that if something in the contract doesn't work, then it has to be rewritten. And that's not a severability clause, and there's no case law that would support unilaterally rewriting the contract in that way. If anything, it simply supports the idea that this is a illusory contract. It can be rewritten at any time. Entrada purports to maintain the ability to replace offensive
Severability
clauses.
is not usually considered an illusory, doesn't create problems of illusory contracts, right?
Right, but
not-
here, it said, the clause that's at issue says that they can replace. It says, If any part of these terms is determined to be invalid or unenforceable, then the invalid or unenforceable provision will be deemed superseded. Deemed superseded. By whom, it doesn't say. Deemed superseded by a valid enforceable provision, and who's to determine that? And the remainder of the agreement will continue in effect.
That
So
most-
there's just no
yeah,
idea what
a
the
valid
contract is.
provision that most closely matches the intent of the original provision, right? It's as though,
Yes, Your
as
Honor.
though a court is gonna like blue pencil it or something, right?
But then that's either the court or a
Right.
party rewriting it. It doesn't provide any procedure for this to happen. It just states it as a fait accompli.
Right.
And so it's just very vague. And so for those reasons, the district court decided the issue correctly. Framed the issue correctly. This is a question about whether an arbitration agreement was formed. And as the court held in Cody, it's only the language that's actually expressed in the contract that controls. And where the drafter can change the contract without notice, it's illusory. And that's exactly what can happen here. That's exactly what did happen here. Entrada changed the agreement by their own admission secretly 3 times in 1 year without telling the plaintiff or anybody else, in public, that it was changed. Again, no revision dates, no suggestion as to what it changed, but it was important. Again, this is just an illustration, but Entrada added plaintiff's landlord as a party who could force her to arbitrate. That's significant.
Is there a document called application for the services?
There's nothing in the record about that, Your Honor.
Well, there is in the contract here. I mean, they're talking about that Entrada reserves the right to verify all information in your application.
I apologize, Your Honor. You are correct. So there is an application.
And that's what in other words, to me, one of the big questions in this case is whether this is an ongoing relationship or isolated trips to the Home Depot to buy fertilizer when you need it. And it seems to me, I'm looking at this agreement, it envisions a long-term agreement, ongoing agreement, like a credit card agreement. You can terminate a credit card agreement at any time, but it's ongoing until you do. And this isn't, I don't know if this is ongoing until you do, but there are a lot of indications in this agreement that talk about licensing and information and checking on your credit reports, and you have to tell us differences and this type of thing, provide information. And I'm not sure you've gone through and given us all the indicia that you think this might be an ongoing relationship, but.
Well, Your Honor, Ms. Santos, for example, spelled out some of the things that are part of the ongoing relationship, that Entrada uses this portal for a lot more things than just collecting rent. In terms of termination, with a credit card agreement, sometimes there's an ability to terminate that. Here, there is no ability for the resident to terminate.
When you
There's
say
only
they
an
use
ability
it for other things,
Entrada.
is that, is the service they provide include notices of subpoenas and this type of thing? Where are the services, list of services that Entrada provides? Is that anywhere?
Well, there's a license to use the site, so that's one of the services, is that they're allowing
I understand,
the
but
use
is
of the
there-
site. I do not believe that this lists out every single service.
Does it provide any list of services?
Well, there is a list of the Entrada text message system terms. This is part of the same agreement, so if you are a resident, this is JA 104, if you are a resident of the property client sending you text messages, you can manage all notifications from within resident portal. So part of the resident portal services include ongoing text messages, and they have a list of the keywords that you can use. Ticket updates, this is JA 105. These would be for repairs to the apartment. If you have opted for text messaging updates while creating a support ticket, you have the following commands, and it lists out commands. Then it talks about in the FAQs, how
So
did
just
I
to-
get subscribed to your
Just to be
service?
clear, you're saying the landlord can use Entrada's service to text its renters notices. That's what it's saying.
That's not what I was suggesting. Your Honor. The way that I read this, it says residents on JA 104, that the property client can send text messages and you can manage those text messages. So yes, the property
Yeah,
client
the
is sending
property
the
client is the landlord, right?
Yes, correct.
Yeah.
So the
It
property
hires
client-
Entrada to
Yes.
be its text messaging service, to send notices about the apartments to the renters.
Correct,
Okay.
yes. And the renters are able to manage those messages.
Right, they can say stop, things like that.
Correct. And then on the next page, it talks about how did I get subscribed to your service? So it says there are two ways you can opt into our services. The first is via the web on a form. The second is by texting a keyword. And so this contemplates a subscription, an ongoing service.
All right. I think your time's up.
And unless there are any further questions, I believe my time is up.
Ms. Santos?
Thank you.
Thank you, Your Honor. There are 5 points I'd like to try to make. The first is my friend suggested that we were trying to retroactively impose the October 2024 terms on all of the transactions. That's not at all true. We cite in our brief, in both of our briefs, all of the relevant pages for Section 1 and Section 3. They did not change in any way throughout any of these versions. So we cite Section 1 is JA 89, 110, 130. It's exactly the same. Section 3, we cite JA 90, 111, 131. So we are applying the terms that apply to each transaction, the terms that were in effect on the date of each transaction. Second, my friend argued that as to kind of the retroactivity questions that Judge Rushing posed, he said, well, there's nothing in the agreement that rules out a retroactive application. There's nothing in the agreement that rules out a unilateral change. And so under the contra proferentum canon, you should basically read the contract as unfairly as humanly possible toward the non-drafter to render it illusory. That is not contra proferentum. I've never seen any Maryland case or any Fourth Circuit case that applies it in that type of way. What it's used to do is to read terms more fairly towards the non-drafter. And that type of kind of formulation of contra proferentum would be completely at odds with Maryland law that says we prefer non-illusory readings of contracts. The third point is on the prospective waiver. I think, Judge Rushing, you're right, we didn't speak a ton about severability because I think it's pretty clear that this case is unlike Hengel and the cases my friend invoked, but I don't think you even have to get to severability because under the Supreme Court's decision in Rent-A-Center, the Supreme Court held squarely that when you're not challenging the delegation to the arbitrator as invalid or unenforceable, and instead you're challenging some other provision as invalid or unenforceable, that is not a reason not to send the case to arbitration. That might be something the arbitrator could look at to say, oh, there's this, prospective waiver. Does that render the contract unenforceable as a whole? But it's no reason to not send the case to arbitration. The fourth
Let me
point.
ask you, why would you put that change clause in that we're talking about, this agreement may change, if every transaction is an individualized agreement? You wouldn't need that if each were, all you'd have to do is attach the terms and conditions. Change wouldn't mean anything.
Because it's to give the tenants a heads up that when they come on and they use the website on different occasions, that there may be different terms.
But it
Because
doesn't matter, because when they go on each occasion under your theory, they're supposed to look at the terms, or they have the opportunity to look at the terms that govern that transaction. And whether it's changed or not doesn't matter because they're individualized transactions. What I'm suggesting is I was just glancing through the agreement a little more here, and you talk about application for services, ongoing relationships, supplying information. It looks like you use the word application, you use the ongoing services type of thing. it looks like you want an ongoing relationship, and that the reason you're putting that clause in is you're assuming that the transaction, the terms and conditions are going to govern that relationship and reserving the right to make changes to it. If you were taking the position as a company that every single transaction is an isolated transaction, there would be absolutely no reason to put that clause in.
I disagree, Your Honor. I think that giving the tenant more information
That
that they should
assumes they
take.
knew what it was. What if the first tenant comes on? I mean, the first person that comes on, you have terms and conditions, they can read it. The person goes on a month later, and you say, that's a new contract, the terms and conditions right there, they can read it. There's no, change is no, you have to assume they're relying on something pre-existing to talk about change.
I think
And
it's
if
in-
you assume they're relying on something pre-existing, then there's an assumed ongoing relationship.
So let me make 2 points, one about the ongoing relationship and one about, why you have this language. On the ongoing relationship, I think it's absolutely correct that Entrada assumes there will be ongoing use of the website because people live in an apartment for a year, 2 years, 3 years. So they might use the website, on all kinds of occasions. But that doesn't mean that there is it's not like a Netflix subscription.
Is it like a credit card agreement?
No, a
Why
credit
not?
card, because a credit card agreement, you sign, you have this kind of like ongoing balance, you have payments that are, that are.
You don't have to. You can do one payment a month, and you can quit at any time, and you can restart at any time.
This would be less like a credit card agreement and more like a rechargeable like Visa gift card where you can use it, so every month, like Miss Trimble used it on 5 occasions, but not all of them, or 6 occasions. So it means that she paid her rent by check or by cash in some months and not others. And so you'll have an ongoing use, but it's not a subscription that you actually have to cancel. There's
Describe
nothing
this,
to cancel.
this email services. Tell me what those are.
The landlord often will send emails out to tenants, just like they send text messages out to tenants. I mean, there's all kinds of services that you can get on Resident Portal. You can reserve like a pavilion for a birthday party. You can leave reviews for apartments. You can read reviews for other apartments. So it's a kind of general service platform. One of the services is that you can do online transactions. And for online transactions in particular, there's this whole section that tells you what binds you when it comes to online transactions. And it says you have to consent each time. And if you don't like the terms on a future occasion, you can just decline to participate.
Okay.
Thank you, Your Honor.
Thank you. All right, it's been an interesting discussion with both of you. We'll come down and greet counsel and proceed on to the next case. All right, the next case this morning will be Mabane versus GKN Driveline North America, and Ms. Hernandez, we'll hear from you.
Good morning, Your Honors. May it please the Court. My name is Jill Hernandez, and I represent the appellant, James Mebane. I will reserve 7 minutes for rebuttal. Mebane asked this Court to reverse and remand for the following 4 reasons. First, the District Court abused its discretion in decertifying the rounding class because it merged the Rule 23 with the FLSA decertification standard despite their fundamental distinctions. Like the Eighth Circuit's holding in Day, the District Court should have held GKN to an onerous burden upon moving to decertify, given its previously conducted rigorous 23A and B analysis prior to certifying the rounding class. Instead, consistent with this Court's holding...
Let me interrupt you if I could, because there's a little more troubling is our jurisdictional issue of your client, Mr. Mabane, settled this case and also pursued his attorney's fees and was rejected, and that was not appealed. And we have no substitution of any representative party. So the question is, why isn't this, with respect to Mr. Mabane, a moot?
Your Honor, thank you very much for that question. There was no unqualified release of claim in the settlement agreement or in the consent judgment. As we know from this court's holding in
Did
Rhodes.
he settle?
I'm sorry?
Did he settle?
He settled, but it did not include an unqualified release
It
of
included
claims.
three things. It included a right to appeal, it included attorney's fees, and it included his fees in other cases.
It included an express preservation of the
that,
right to
but,
appeal, and consistent with this court's holding in Tom's, it's a two-pronged test.
No,
Even if you can.
Tom's is at odds with your position, I think. I mean, we specifically said in Rhodes and Tom's that when a party voluntarily dismisses the individual claims, that party lacks standing to go forward.
That is correct, but there is also a concrete
Is
financial interest.
that not what happened here?
He did not, he only settled his individual substantive claim, but he did not release the financial interest with respect to his attorney's fees and costs and with respect to his right for a potential service
He
award,
exhausted those. He filed a petition for attorney's fees and was turned down, and he didn't appeal.
but not without prejudice, Your Honor. So to the extent that this court would reverse
But we
and
don't
vacate,
review
then he
something.
would be able to recover
not
the attorney's
appealed.
fees.
Do you know that you keep talking when Judge Niemeyer's talking?
I'm so sorry, my apologies.
Thank you.
Judge Niemeyer, I'm
No,
sorry.
go ahead, go ahead.
So again, the district court consented and approved the settlement agreement and the consent judgment. It had the express right to appeal as well as a financial interest in the attorney's fees and cost. And obviously by moving for the appeal and pursuing with that, that to the extent that he would be able to have this reversed and vacated by allowing the plaintiffs and the opt-in plaintiffs and the class members to be able to recover their unpaid wages, then he would be able to also recover the service award.
He
Not
doesn't
to
have a
mention,
substantive claim.
I'm sorry?
He doesn't have a substantive claim for wages of any kind. He can't represent somebody else as a representative party under Rule 23 or the collective action under the, unless he has a claim himself. And he settled his claim, and the interest in attorney's fees you're talking about, he exhausted and has not appealed. We don't have that before us. And so the only other thing would be fees in other cases, but you'd have to assert that in those other cases.
And Your Honor, and I do recognize that, but again, in light of the fact that to the extent that this court would reverse and vacate, then he would be able to shift the attorney's fees and costs to the remaining class members. Not to mention.
Didn't we, in Rhodes, we rejected the idea that the cost shifting of the fees, so there's two ways to have standing, we recognize, right? One was the substantive claim, one is potentially the cost shifting. And in Rhodes, we specifically cabined that second way, the cost shifting way. So that's only available to plaintiffs who have involuntary dismissals, is what we said, right? When they've been forced to settle. And we specifically said when a plaintiff voluntarily dismisses the individual claims, that ground for standing, that fee shifting ground, is not available, right? So is there anything left? There doesn't appear to be anything left after Rhodes for you.
Now, Your Honor, to the extent that, again, should this court find that there is jurisdiction because there is a potential for a service award, there have been cases that
But
have
not in
recognized.
this case. There's no potential for a service award in this case, right? He didn't reserve that.
Well, there was no unqualified release of claims as it relates to his potential recovery as a class representative.
So since
Didn't he-
Rhodes
didn't he
doesn't,
Generally
ahead.
waiving all remaining claims?
There
That's
wa-
that's in there, right?
it says there is no explicit language that he was relinquishing his right as a class representative and the financial award that would go with that. Some of the other agreements explicitly
So
have that
since
sort of
Rhodes doesn't
language.
support your position, what do you think is the best case that supports what you're arguing about?
Well, the way that we interpreted, for example, Tom's, is that it's a two-prong scenario. Even if there is no underlying individual substantive claim, there is still a potential for the attorney's fees and costs because there's a carve-out relating to that. And the district court did not dismiss or deny the attorney's fees with prejudice. So to the extent that is still an open question in terms of those attorney's fees and costs for Mr. Mebane, the class representative. But moving further to the plaintiff's exact claims here, and the purpose of the appeal is that, again, should this court find that Mr. Mebane properly invoked the jurisdiction of this court, that there does remain to be a concrete financial interest, whether through the attorney's fees or his right to recover a service award because he did not relinquish his right as a class representative, then the next point would be that the district court abuses discretion by materially misapplying Rule 23C when it failed to distribute notice after certifying the automatic deduction class. The Supreme Court in Eisen versus Carlisle affirmed that notice is not discretionary but an unambiguous requirement. Here, notice to the class members.
It never reached that point.
I'm sorry?
It never reached that point of giving notice. There was a motion for reconsideration, and ultimately there was a determination that the classes were decertified. The court has to give notice at some point, but there's nothing that mandates it give it before any particular ruling. This is all discretionary on managing a class.
Well, Your Honor, what we understand from the Supreme Court, again, the holding in Eisen, is that that's an unambiguous requirement. We have cases from this.
Of course it's a requirement, but you have to give notice to let people opt out, but the class never got that far.
Right, but given the fact that the district court had actually granted Rule 23 certification, then the appropriate thing to do at that time was to send notice to these individuals. At this point, it has been an indefinite.
Wasn't there a motion for reconsideration filed to that?
There was a motion for reconsideration.
And the court then considered that motion, didn't it?
It did consider that motion.
And then it decertified, didn't it?
It decertified at the end, even though from August of 2022 until May of 2023, this remained as a certified class. And so what we know from.
The court had it under reconsideration, and the court's not going to give notice while the question of whether there's going to be a class is up in the air. I mean, this is just you're asking to say that the court abuses discretion on the timing of this. It has to give notice. A class action requires notice. It's a constitutional requirement, actually, on a B3 class, to have notice and opportunity to opt out. But the question of whether the court should have given notice before it resolved whether there was a class action is a strange claim.
But, Your Honor, and I accept and I understand and acknowledge Your Honor's position on that. The concern here is that if after a district court certifies a Rule 23 class, there's going to be a defendant that immediately files a motion for reconsideration, and that will just simply delay the matter
Well, it's up to
indefinitely.
the court may say that the motion for reconsideration is nothing. I'm firm on my class and issue notice. Or the court may say, well, there's something to it. I'm going to hold up on notice until we determine whether it's appropriate. That latter is what happened in this case, right?
Well, the concern here was that in decertifying, here was even more, what was more problematic, that by the time the district court in May of 2023 decertified the automatic deduction class, the court relied almost exclusively on GKN declarations. And what we know from this court's holding in Brown is that district courts have to proceed with eyes wide open to the power imbalance, the potential for coercion, and that these are essentially current employees that are, subject to these concerns. And more significantly, at the time when the district court was analyzing those declarations, it should have kept in mind limiting the value or the weight of those declarations because of the power imbalance, limiting the probative value overall, and looking more importantly at the representative testimony of class members, the common evidence that was at issue. There was overwhelming common evidence. There were two common policies with respect to the Rule 23 certified classes. One was the rounding class, one was the automatic deduction class, and those were the overarching questions, overarching common questions that had common proof that certainly could go to the jury for the jury to decide class-wide liability and damages, Your Honor. The other thing is the district court essentially ignored the representative testimony here. There was representative testimony as it relates to how all of these individuals were subject to the same common policies, the same the rounding policy, and the question about the rounding policy was whether or not it was neutral. The parties had competing proposals about the lawfulness of the rounding policy, and with that information, the plaintiff's expert had statistical evaluations and analysis that demonstrated that that rounding policy wasn't, in fact, neutral, that it was being utilized to undercount the employee's actual hours worked. There were timekeeping policies expressly stating that GKN wanted to ensure that employees were clocking in and clocking out to keep an accurate reporting of hours worked. And then we had the actual time and pay data, the pay policies that affected all of the hourly employees. All of them were hourly employees. All of them were subject to the rounding policy.
Red light is on. We'll get you back on rebuttal.
Thank you so much, Your Honor. I appreciate it.
Mr. DeCamp.
May it please the court. I'm happy to answer any questions the court may have. Thank you, Your Honors.
All right, Ms. Hernandez, you have some rebuttal. Not much to rebut. You can come up.
Your Honor, the only other thing that I would say as it relates to the FLSA decertified analysis. So just simply wanted to make sure that this court understood that, again, with respect to the rounding policy and the way the district court unfortunately failed to hold GKN to its burden of demonstrating that a reexamination of Rule 23A and B was warranted, the district court failed to do that. It was the district court's responsibility to ensure that the class remained certifiable. And because it didn't do that, then it failed to, again, hold GKN to its burden. Secondly, as it relates to the FLSA collective.
I'm not sure the court had any burden. I think the burden was on you.
Your Honor, the other concern that is at issue here is the FLSA decertification analysis. The district court engaged in an overly restrictive application of the FLSA's similarly situated analysis. It essentially focused on the variation of activities and the length of time, as opposed to focusing on whether or not these individuals were subject to a common policy, looking at all of the different policies in place and the representative testimony, and demonstrating that there was finding, or at least determining that there was enough information here that would have warranted denying the defendant's motion for decertification and allowing a jury to rule on potential class-wide liability and damages. Other than that, Your Honor, unless Your Honors have any questions for me, then I will, I see my time has expired.
All right, thank you.
Thank you very much.
We'll take a brief recess, but before we'll come down and greet counsel.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, next case we're going to hear is Rhodes versus Riddell, and Mr. Lindeman will hear from you.
Thank you, Your Honor. May it please the court, Andrew Lindeman on behalf of the appellants Eric Riddell and Jessica Whitaker. Your Honors, this is a second prong qualified immunity appeal. The issue before the court is whether the conduct that was expected of Lieutenants Riddell and Whitaker was clearly established back in May and June of 2019. The plaintiff's theory in the case was ultimately that the appellee had a medical issue that worsened over the course of her 1 month at the Aiken County Detention Center. She was undergoing ongoing medical care by the medical staff, both the nurses and Dr. Williams, who were previously defendants in this case. And the record will show, and I think it's undisputed, in fact, a lengthy recitation of the medical history during that 30-day stay at the Aiken County Detention Center is contained in the plaintiff's complaint, that the plaintiff had at least 20 encounters with medical personnel during those 30 days, and that's not even including...
How many did she have during the time she was in solitary confinement?
She had numerous during that. I was in fact...
Could she access the kiosk to ask for medical assistance while she was in solitary confinement?
The kiosk was available to her, and also the testimony was that one of the
thought she said it
correctional
wasn't.
officers actually assisted her in sending grievances.
Judge Niemeyer just said something.
I
Did you-
thought she said it was not available when she was there.
That's correct. I mean, her testimony is that is an issue in dispute, but of course, this is a second prong.
A minute ago, you said
analysis.
the facts were undisputed.
Well, what I was telling the court was that the medical history is contained in the complaint, and what I think is very important to court to recognize, in addition to those 20 encounters, there were also numerous encounters, particularly during the period, or in addition.
Well, I don't think
during-
we have jurisdiction to review facts that are disputed, the disputes of fact. We've explained in many cases, but we just came out recently in Barracks versus Wright and explained it pretty explicitly that under Johnson, Supreme Court case in Johnson, we're not to review district court's dispute of facts in concluding that summary judgment was unavailable. What we are able to conclude in that context is if we take all the facts alleged in the light most favorable to the plaintiff, would the defendants be entitled to immunity? And if those facts, if immunity couldn't be awarded then we'd send it back for resolution of the facts.
And I recognize that, Your Honor, and that's why
Yeah.
if you look at the nature of how the appeal was postured and what I just stated in my opening remark to the court, is this is a second prong analysis. So the question here
Well, then you have to
is-
take all the facts the way she has alleged them.
That's correct.
And determine whether there would be immunity under that. And that starts getting sort of difficult for you if you have to take them on that basis, because she alleges some pretty difficult circumstances. I mean, this growth on the side of her head was the size of, she said, the size of a grapefruit. And that's pretty large for the higher ups to say that, oh, that's just self-infliction.
Well, ultimately, the key fact in this case, which is undisputed, is the medical care that was provided and was ongoing. And to finish the point I was going to make, in addition to those 20 encounters, multiple times a day, even after she was put in segregation.
But you're not arguing that there's an immunity granted to the officers because their medical people were looking at her?
That's what we're asserting. We're asserting that because there's ongoing medical care, that the clearly established law.
What if the medical care has gaps in it and the officers see conditions that they should be addressing? I mean, that's her theory. Her theory is she's in solitary confinement, she doesn't have a kiosk to alert, And at that point, it was getting worse, and that the officers did get summoned, and they spoke up the line to someone, I don't remember who it was, and he said, oh, that's just self-inflicted, and didn't take her to the hospital, and or didn't give her medical treatment at that point. And at that point, she said her cyst was the size of a grapefruit.
Well, she had just been seen by Dr. Williams on May 23rd.
And he saw, did he report a cyst the size of a grapefruit?
Dr. Williams diagnosed her with a hematoma and prescribed medication as well as warm compresses. Ultimately, and again, this is a key point, even while she was in segregation, she received medication, and so during MedPass, that was provided by a nurse, so she was seen twice a day.
Ongoing complaints and ongoing symptoms she complained about. My only problem is, you may be absolutely right. The problem is a little bit of a structural problem, is that when we have a summary judgment and the district court concludes there are disputes of fact, we can't review that issue. What we can do is we can re-look at the record and say, okay, we'll take the facts in a light most favorable to the plaintiff, which is not a real statement of facts, because we don't know how they're going to be resolved when a fact finder resolves them. But you may be absolutely right, but she tells a notion of abandonment, and nobody gave her attention, and she I don't remember all the personal symptoms, but they were pretty tough to ignore.
And she's not alone in that telling. There are two other correctional officers that support her recounting of the facts.
But again, I mean, if you look at Joint Appendix page 20, the plaintiffs go through the medical care that was provided. May 28th, she was seen by personnel. May 29th.
That's perfectly fine, but that doesn't help the portions where medical care was needed and wasn't given. She had the two officers view her, and they thought something needed to be done. They reported up the line, didn't they?
They reported, the allegation is, yes, that they reported up the line.
And what did they report?
They reported that there was, obviously, that she had a protrusion on the side of her head.
That's all they
And
said?
that was
and that
obviously
they thought
known.
that she needed medical care and that they did not believe it was self-inflicted. Those are the allegations.
Sure, but of course, ultimately, to Lieutenants Rydell and Whitaker, she was receiving ongoing medical care. It is undisputed that she was receiving it. As I indicated, she was seeing a nurse on MedPass at least twice a day. And again, this is
What if
even
an
after she
officer
was.
An officer saw a prisoner, inmate, with a broken leg, compound broken fracture, and the nurse said, here, take some Advil, and that'll be all right, it'll heal eventually. Does that relieve the officer of reporting this further and seeing that the leg gets reset and taken to the hospital?
Well, if it is absolutely clear that the care is not being provided, or if no care is being provided, such as what occurred in ICO, in this particular case, to these two lieutenants, she was receiving ongoing care. There would be an expectation, and I would submit a very dangerous one, to expect non-medically trained personnel, such as Rydell and Whitaker, to second guess and
They were
override the
second-guessing. They were
decision.
making an observation that they personally saw, and they thought that this woman needed help.
And
And they reported it to their superior, and the superior says, oh, it's self-inflicted. And
no,
what did he say? What did he say?
the allegation was one of the nurses said it was self-inflicted. There's no
And that ended
there's no
it?
allegation that any of the officers said it was self-inflicted.
And
But that didn't-
And that ended the inquiry by those officers, right?
Well, that ultimately they recognized, and it's undisputed, that they were receiving continuing care. She had just seen the doctor. She was ordered for a CT scan on the 28th of May. And so the point of our motion and the point of our position is that there is no clearly established law, either in this circuit, and I couldn't find the case anywhere, and certainly none has been cited to this court, finding that correctional officers, when there's recognition of ongoing care, that's a difference between ICO or a difference between Cooper versus Dykes where the medical care was over or never existed to start with, that there would be an expectation for the correctional officers, again, non-medically trained, to override and second-guess the decision of the medical providers and to attempt to provide a second or different course of treatment.
Can I ask you about that? Because I think you've emphasized this is a second-prong qualified immunity appeal. It's only about whether, if the facts are, as the district court found, a jury could conclude they are, was the right clearly established. So it really restricts what we have in front of us and what we can consider. And the district court said a jury could conclude that the defendants knew that their inaction posed an unjustifiably high risk of harm, even though she was receiving medical care. So that's the Eighth Amendment, right? So a jury could find that these defendants knew, even though the plaintiff was receiving medical care, that by doing nothing, they were creating an unjustifiably high risk of harm. So we have to then ask, was it clearly established, right, that there's a right to do nothing in that scenario? Is that the right, I understand that to be the right question.
And the theory, again, I agree with the way you postured that. The theory is that what they should have done was to seek an alternative course of action, sought additional or different medical care for Ms. Rhodes. And there is no constitutional duty to do so, and there's no case holding that they should do so. So even if they recognized or thought to themselves, maybe this care is deficient, it's really not within their realm.
Not maybe, even if they knew that doing nothing posed an unjustifiably high risk of harm, it was not clearly established that they were required to do anything other than nothing.
Well, of course, recognize too that, and that's one of the things that's challenging in this case, is it was analyzed on reconsideration by the district judge under the Short v. Hartman case, which was not in existence in 2019, and in fact was not
Right,
in
but
existence.
she did both, right? She did the short analysis and she did the Eighth Amendment analysis and said that a jury could find they actually knew that there was an unjustifiably high risk of harm. That, to me, is the holdup here. Once we have that, and they take no steps at all to do anything.
But what's the expectation? What are those steps? That's where the
Well, that's your
issue-
problem, right? It's because in every case that we have on the precedent-wise, something happened, right? Anything at all. And then the question is, well, were they constitutionally required to do something other than what they did? But it seems that there definitely is precedent saying they're constitutionally required to do something.
Okay, and so then the question is, Judge Rushing, what is it that they're supposed to do? There's no case law, there's no authority telling these officers what it is they're supposed to do. There's case law, like ICO.
What does an officer do when he sees somebody in a cell with a broken leg?
He summons medical care, and in this particular case,
And they
there
didn't
is
summons
ongoing
medical care
care.
at this point either. They just left her.
And no, they didn't leave her. She was receiving ongoing medical
No,
care,
I'm
CT
talking about,
scans.
let's stay with this factual scenario
Oh,
where
you're-
she reports that she complained, the officers shared her view, reported it upline, and nothing was done. That's her statement.
That may be her statement, but the record shows, and again, the plaintiff's own pleadings show, that she was seen by medical on the 28th of May. On the 29th, she received medication on the 30th, so she had interaction with nurses on those days. She continued to get medication by the MARs on the 1st, and on the 2nd, she was seen twice, but before she was ultimately sent to the hospital. So there was ongoing medical care.
What date was she sent to the hospital?
On June 2nd, 2019.
And what was the last date she had medical care?
On that particular date. She fainted earlier that day, that she was seen by medical, and then she ultimately had a second episode during the afternoon, and the decision was made by the medical personnel to send her to the hospital. And she was seen by medical personnel.
Because at that point, she had fainted twice that day and was vomiting and running a fever.
Well, the issue again is...
And those things had happened before. That wasn't the first time.
That's right, but...
And the question is, can the officers stand by when they know there's medical care needed and do nothing? And she alleged that they did nothing, that the two officers thought something should have been done, and they reported, and as a result of their report to a superior, I didn't think they reported just to a nurse. I thought they reported to somebody else.
No, it was the nurse that alleged supposedly that she was self-inflicting, not the officers.
Okay, yeah, but
That's the
who did
point.
the officers report their claim to?
The evidence is that they reported it to both of the lieutenants. But the
And what
lieutenants,
did the lieutenants say then?
the lieutenants knew at that point that
Now,
there
what
was
did they say
ongoing
to the
care.
officers?
Ultimately,
No, at that point.
well.
The two officers responded.
Right.
What did the,
Lieutenant Rydell allegedly indicated to Deputy Kelly that they can't override medical. And ultimately,
that's not right, right?
no, I would agree that that's right.
nothing?
I think that's the
He
focus
says
of
it's
this
right.
case.
You think
That's-
it's right,
Yeah, I believe that you cannot expect, and in fact, Miltier versus Boer.
no matter
numerous
what,
cases
no
of this
matter
court.
what.
Well, particularly unless it's something just absolutely obvious, like somebody's bleeding out.
Like a grapefruit size thing on the side of somebody's head that's causing them to vomit and faint and pass out and.
But the record
And
shows
the officers observed it?
she was being treated for that.
Well, doesn't this-
It was diagnosed.
With Tylenol.
Doesn't this go
Good for
to
them.
the question of deliberate indifference, though? It seems like your argument to us this morning is just saying a jury could find that because there were medical professionals involved, the officers weren't being deliberately indifferent, right? They didn't know something else needed to happen. They were relying on medical.
That's correct.
Which, like, a jury could totally believe. But that is the prong you keep telling us is not in front of us. The prong that's in front of us is if they knew that they needed to do something other than what medical was doing, and still they didn't, is it clearly established that that violated the Constitution?
And-
That's the question.
That's correct. And so the question as we posed it was whether or not there was a constitutional duty when there's knowledge that someone is receiving ongoing care for a medical issue, and that's undisputed in this case, that they had a constitutional duty to second guess or override the medical personnel and attempt to seek
When they
an alternative
know,
care.
when they know that the medical care is not adequate, right? When they know that something else needs to be done, do they have an obligation to do something else?
Well,
That's the question.
they're
We have,
not,
we have precedent holding non-medical officers liable, right?
but you have precedent holding non-medical officers liable when there's no medical care being provided as an ICO, or when the medical care occurred in the past and is not ongoing and additional problems arise, which is Cooper versus Dykes. There is no case that I'm aware of, and none has been cited to this court, where the officers are aware that there's ongoing medical care for a medical issue, which obviously they're not
So you don't
trained to
ask
be
the
able to.
right question. You keep positing the safety of relying on medical care. The question is when an officer believes that something needs to be done and sees that something needs to be done, two officers report that there's something serious going on, and then they're told, don't worry about it. They did nothing. Now, the question is, this is a joint effort. This is not these officers have an independent constitutional duty to make sure that medical care is provided. And if they see it's not being provided, they have to do something. And that's her version. May not be the right version. But you have to give her credit at this stage for her version, don't you?
Well, I disagree with you, Honor, because again, that it's undisputed in the case that she was receiving ongoing
Okay,
medical
I
care.
understand that.
And,
Okay,
and,
yeah.
and in fact, on May 28th, a CT scan had been ordered. It obviously was ordered for several days post, but the record clearly shows, and I see my time's up, I didn't even
Yeah,
notice,
why
and I
don't you
apologize.
bring
for
it
that.
back on rebuttal?
Thank you,
Yeah.
Honor.
Did you say your name was Linda Baum or Linda Men?
Linda Men.
That's what I thought. I misheard you. Okay.
All right, thank you.
Mr. Lewis?
May it please the court, Will Lewis, along with my colleagues, Mr. Brink Henson and Dixie McCollum, on behalf of Mrs. Rhodes. Your Honors, I think the questions that were posed by, frankly, all of you gets right to the point. But to drill down on this second prong analysis and this immunity that's being posited by my friend, Mr. Lindeman, just because medical is consulted, was disposed of actually by this court in short. If you go into the opinion in short and you actually go to page 614, one of the arguments in that was the fact that the nurse in the short case made a finding that there was no suicide risk. And so the non-medical defendants in that case said, well, I can rely on that to do nothing. But there were obvious things in front of them saying that they were suicide risk, and they did nothing. And what this court said was, they can still be liable for their own actions because holding otherwise would shield non-medical defendants from liability whenever medical personnel is consulted. This was the conversation that you were having with Mr. Lindeman is, well, what if they see it with their own eyes? In this case, it's not just doing nothing, Judge Rushing. It's actually worse. So what happened in this case was the nurse did think that she was self-harming, all right, when she had this abscess in her head. The two subordinate deputies did not believe that. They had been watching her closely, and they said, we do not believe they're self-harming. They reported that to Lieutenant Whitaker. The record reflects that Lieutenant Whitaker said, and this is Deputy Kelly's testimony in her deposition that's in the record, that I will inform medical. That was not done. So think about that. Not only did they do nothing, but when a subordinate came up and said medical's assumption as to the diagnosis that's causing these problems and placing this person at extreme risk is wrong, and they did nothing. And they went a step further. When these subordinates, it was Deputy Kelly predominantly and Deputy Hill, were coming up to Lieutenant Rydell, Mrs. Rydell, they were saying, we don't think she's getting enough, that something needs to be done again and again and again. And they went around Rydell, and they went directly to medical. And what did Rydell do? He said, stay in your lane. He was actually restricting the flow of information, not just doing nothing, but restricting the flow of information regarding her circumstance and how she was supposed to be treated. The facts are to be taken as you, but when we actually look at them, it's worse than doing nothing. The predominant argument by my colleague, Mr. Lindeman, is that this is not a clearly established right. Judge Rushing, you hit that right on the head. There is precedent that when we're seeing an actual known risk that places this person at severe harm, that is a detainee, whether it's being post-conviction in the 8th Amendment or in the 14th Amendment, a pretrial detainee, failing to do nothing is a violation.
This is pretrial, right?
This is pretrial, Your Honor. And one of the good things about this and how it was decided by Judge Lyden is very similar to Short, and you noted this, Judge Rushing, is that she did both the pre-Short subjective test, right? And we did the post-Short objective test.
Right, because they're, for qualified immunity, for clearly established, she looked at the pre-Short standard, because that's what the officers were operating under at the time.
Correct. And then we know from the deliberate indifference standard in pre-Short, the second prong of that, right, when we're kind of actual knowledge of risk and a deliberate indifference to that, that generally you're not even entitled to qualified immunity. It's at this court held in Thorpe that when we have a knowing violation of the law, that culpable mindset, which comes through this case law, that qualified immunity is not in play. So what's interesting
The
is...
Supreme Court has said it is. I mean, we've kind of gone back and forth on what to do with
Right.
Thorpe.
And so if you go in Paffaller v. Amonette, they kind of give the two spectrums, right? You have the
Yeah.
Taylor case
Yeah.
versus you have the Thorpe case. But I think the distinction from this court is what you're going to apply is the direct action of the defendants and the known and obvious risk kind of takes you out of the Taylor and puts you back into the Thorpe. In fact, in your opinion, in Paffaller v. Amonette, they talk about that distinction and they say in jail cases that it's actually the most appropriate to the Thorpe analysis because we actually have specific intent or at least a culpable state of mind that they are violating the law. So now how can they hide behind the shield of qualified
I
immunity?
think I heard sort of a through line in Mr. Lindeman's argument, the proposition that it would be dangerous precedent to require correctional officers to second-guess medical professionals. What's your response to that?
If it was a purely medical decision, yes. But similar to Short, when they place them in solitary confinement, and we have non-medical decisions that are impacting the care. So it's not a second guess, but they're actually decreasing the flow of information. They're depriving this woman of talking through medical grievances to her medical care. And they're actually knowing that one of the bases and assumptions for the diagnosis is incorrect based on the facts that they're observing. Depriving that of getting to medical care, we're not in second guessing. We are in prohibiting adequate medical care at that time. Now, as you noted, Judge Niemeyer, I may not be able to prove that at trial.
And
Right.
using medical professionals as cover.
Right. And that's the ICO case. You actually mentioned it in Short. I mean, there were medical professionals done in ICO and Short. I think the factual distinction would be how many times they were seen, albeit I don't think that really applied to the analysis. But you don't get to hide behind the fact that somebody saw a nurse and then ignore obvious risks I mean, one of the things that is shocking in this case is we talked about the last visit of the doctor when they were in BMAX. The observation that he made was that that abscess was about $50. By the end, we're at a grapefruit-sized head. And it's not just the deputies that are noticing this. The inmates are also reporting it. This is obvious risk by a layperson that being relayed to these individuals who are responsible for giving adequate medical care. And they're not only doing nothing, they are actually prohibiting that. And I think that's what takes us out of this. I mean, we cannot give blanket immunity. I think it'd be more dangerous to say there is blanket immunity to non-medical personnel as long as they saw a nurse, as long as they saw a doctor. And then how many times do they have to see it? And this is why when we go into the subjective test, that second prong is already clearly established through the deliberate indifference second prong. I mean, that's what the case law has gone. And I understand the distinction with Taylor, but we're not in a protocol scenario, right? I mean, Taylor was a suicide protocol where we had an attenuation from the actual defendant. So we're not in that standards. We're actually in direct interaction. And what's interesting is I think you can actually go into the cases that my friend Mr. Lindeman cites just to kind of get the distinction. You know, when you rely on medical care, we don't want our prison officers to have to be medical providers. But those cases are like methadone overdoses, about the amounts. They're going to be when there's no serious injury and there's just a disagreement on the course of care. In this case, we had a deputy come to the lieutenants and say, on my day off, can I please take her to the hospital? It's obvious. There is nothing that takes this. We are only holding them liable for their own actions, not the actions of the medical personnel, albeit I think it's very negligent. And at this point, the court gave you facts to make that finding that they were on actual notice of the risk, and they deliberately ignored that risk. And so that second prong is satisfied. Your Honors, I do want to, before the last thing I'll say, and I know I've got plenty of time left, and I'm happy to answer any questions y'all have on the Second Amendment prong, but hearing no questions, and I think I've addressed them from your discussion with Mr. Lindeman. There was stuff in the brief about the consideration of the materials, because we had the ongoing state court case at the same time as the 1983. This is in the brief. It wasn't raised in his oral argument. I would note, to the extent that that argument is raised in reply, the district court in footnote 4 said she didn't consider those materials. I don't think it's jurisdictionally in front of you anyway.
Let me ask you, it was a curiosity, I saw that she didn't, and probably isolated that data, but those data. But would a jury's fact finding that overlapped with the constitutional claim, is there any claim preclusion as to that?
I do not believe there is any claim preclusion as to that.
Okay.
In fact, I mean, if we're going to consider it, what's fascinating about this case, right, and just to give you an idea, if you're thinking about the state court case, I mean, there was a reckless finding in that for these exact actions under gross negligence in South Carolina law. And the way it was described in that, which I think is apt for what we're thinking about in this interplay of consulting with medical professionals and the duty of these supervisory lieutenants, is in closing argument, actually, Mr. Henson, and I know we're not considering the state court, but this is just to frame the issue. He said to think about it this way, you know, if I take my child to a pulmonologist for breathing bad, and that pulmonologist says, I've got it. The diagnosis is she's allergic to cats, and the cat in your house is exacerbating that allergy. And as the parent, I know there's no cat. What am I going to do? I'm going to say, you're wrong. In this case, we have medical professionals saying this is attributable to self-infliction, and people are watching her, and they know it's not self-inflicted, yet nothing is being relayed, and they're actually being prohibited from relaying that to medical professionals. And then just to add one inference that can be drawn from this, as I was preparing for this argument with this contention that these people were not deliberately indifferent, when she's in BMAX, for days these people are reporting that she's self-inflicting, okay? That's what the diagnosis is, and we're going from $50 to a grapefruit. If we were giving adequate safety protections to a prisoner, wouldn't you think there would be some restrictions to prevent that self-harm? Not only ignoring the medical, but even the diagnosis of self-harm that could lead to further harm to this person, an absolute risk, they're ignoring that and doing nothing about it. So either way you slice it, there's just not an argument that the second prong of the qualified immunity analysis was not satisfied, especially from the factual findings by Judge Lyman.
Well, it has to be based on the factual findings of the plaintiff taken most favorably to the plaintiff.
Without question, Your Honor, and I've always been told to not talk when I don't need to, so unless anybody has any questions, I'll rest on my briefs.
All right, thank you.
Thank you.
All right, Mr. Lindeman.
Once again, I didn't hear a single case that was cited to this court that addresses that there's a constitutional duty under a factual scenario such as this for correctional officers, knowing that there's ongoing medical care provided to a detainee, to second-guess those medical opinions or medical
Well, see,
decision-making.
You reframe the facts by calling it second-guessing, when the second-guessing is not a medical conclusion, but the second-guessing is whether it's self-inflicted. And the officers noted that it was not, that it was growing, that she was unable to report it, and they reported it. Now, why would two of them, observing her, who's got this grapefruit-sized cyst, and she's fainting and she's vomiting, why would they go and report that, that serious medical condition, and then nothing's done in reaction?
Well, this whole,
The response was nothing, right? Nothing happened. The nurse did nothing, Whitaker did nothing. In other words, when that report came from the two officers, it hit a dead end, factually.
well, I disagree, Your Honor, because.
What happened?
Well, she continued to receive medical care. I mean, she continued, and again, I would encourage the court to look at the complaint itself on page 20 of the joint appendix, paragraph 27. SHP medical records dated May 28th reflect that medical staff responded to BMAX to deal with the plaintiff. Paragraph 28, the very next
Yeah, but you
day.
can't just stick with that. You got to go to all the facts, right? We're talking about a summary judgment record in which you take the facts most favorable to the plaintiff, which I don't think you're doing myself. To be fair, the plaintiff has a story that basically I was in medical distress, serious medical distress, and correctional officers observed the extreme medical thing, and they reported it upline, and it went nowhere. Nothing was done in response to their report.
It didn't go nowhere. She continued to receive medical care on numerous encounters.
Except you have to focus on what Whitaker said and what the nurse said. That's the response to what the officer said. They said, we need something now, not we don't need this ongoing. What they said is, the nurse said it's self-inflicted, right?
No, the allegation was that one of the nurses, yes, that Nurse Donna said it was self-inflicting.
And what did Whitaker say?
Well, there's no evidence specifically as far as what Whitaker said, I believe, in the record.
Who was the officer, lieutenant they reported to?
Ultimately,
These two officers reported it.
right, ultimately, Nurse
Let's get to the
Kelly,
facts.
Nurse Kelly reported to Lieutenant Rydell.
And what did
his
Rydell
ultimate-
say?
And Rydell said he was not in a position to be able to override medical. And so, but my point.
So then one of those other correctional officers went actually to medical and reported, I don't think this is self-inflicted and we need more help here. And then one of the appellants said, stay in your lane or something.
But again, this whole.
Well,
idea
is
of
that
self-
accurate? Is that accurate?
That's what the allegation
allegation,
is.
okay.
Yes. But what's key is that whether it was self-inflicting or not, she wasn't denied medical care. She continued to receive it and received ongoing medical
Right,
care.
and your argument is that it sounds like, as long as there's medical care, it does not matter what the facts and circumstances are, the correctional officers have cover.
Under a scenario like this.
And
where they
that's a
cannot-
dangerous precedent.
Where they cannot diagnose that it would be, that the medical care was inappropriate. She was receiving medical care. It's not up to these officers or
But that,
the,
see, that wasn't a diagnosis. That's self-infliction, and that's what they were doubting, that this was self-inflicted, because that's what they were told. And they said it's not self-inflicted. And I think wasn't there evidence that inmates observed that too?
but, Your Honor, whether it was self-inflicted or
My-
not.
So, yes.
Just a minute, I want to get to my question. My
Sure.
question was that that is not second-guessing a medical decision. That's second-guessing a causative decision of whether she's self-inflicted or not. And the point is, the officers had good reason to doubt that this was self-inflicted, and yet they were not accommodated.
But whether it was self-inflicted or not, that would be pertinent if the nurses said it's self-inflicted and we're not providing any medical care. that's not the undisputed evidence in this case. Whether the nurses, well, first of all, Nurse Donna denied ever alleging that it was self-inflicted, but the bottom line is she continued to receive medical care. If somebody self-inflicts in a prison, they're provided medical care, even if they self-inflict. That's not a basis for not providing medical care. And in this particular case, she was continuing to receive medical care. A CT scan was ordered for her on May 28th by Dr. Williams. Ultimately,
Was it conducted on May 28th?
no, it was scheduled for June 5th, and she was in the hospital by that point.
I know.
So ultimately.
That's hardly useful, is it?
Well,
I mean, she's
sometimes-
lying on the floor vomiting and with a fever and with this grapefruit size, and they say we schedule something 5 days in advance or 6 days in advance. I mean, something's got to be done right now, doesn't it?
Well, ultimately, they were providing care, and you can't expect these officers to second guess that. I think it boils down to that.
Okay.
If I can make one additional point, I see my time's up.
It is up, but go ahead and make your one.
I just wanted to cite this court in Rice versus Adams in 2026. I think, Your Honor, Judge Niemeyer, you were a part of this case, specifically said this, that medical professionals examined Rice several times as detailed in the complaint further undermines any inference that the officers acted with deliberate indifference, even if they should have known that she was undergoing withdrawal. For when a detainee is under the care of medical experts, detention officers will generally be justified in believing that the detainee is in capable hands. Whitaker and Rydell were justified in believing that they were in capable hands, that Ms. Rhodes was in capable hands. And certainly there's no case law, no authority that suggests they had a duty to seek any type of alternative care for her, and therefore she would be entitled to, or these officers would be entitled to qualified immunity. Thank you, Your Honors.
Thank you. We'll come down and greet counsel and proceed on the last case. All right, next case we'll hear this morning is United States versus Colette or Cholette. I got to find out what the right pronunciation is. We'll hear, I guess, first from Mr. Gelfand.
Good morning, and may it please the court. The district court literally amended the indictment, constructively amended the indictment, abandoned this circuit's long-standing precedent that a literally true statement on a government form cannot be the basis of a criminally false conviction, and impermissibly admitted evidence of Mr. Cohn's prior criminal tax conviction from 2002.
You know, you're relying on that Seventh Circuit case for the literal truth, and as you know, the Seventh Circuit case held that a space on the form called for a W-2 income, and the court said that was literally true, put on the W-2 income, and other income was not put in. And so the court recognized there was a problem there. Yours is a deduction for business expenses that were never made, just totally fraudulent and made up according to the jury's finding. And to me, that's a non-starter. If you want to spend time on that, you can go ahead. I'm speaking only for myself, but the form here put in deductions, business expenses for intellectual property and fees for services that were never provided. And at least that's what the record shows. And so I we're not here to try to justify a fraudulent entry with a literal truth. There's nothing truth about it.
And I appreciate the court's comments. I would very, very briefly, respectfully push back on the interpretation of Reynolds, because each of the 72062 counts in this case only alleged by explicit line number in the indictment the total income line, which is exactly analogous
But
to
it
what
was
the Seventh
made
Circuit
up
said.
of a fraudulent deduction. The income was reduced by business expenses that were fraudulent, that did not exist. There's no literal truth about something that didn't exist.
Your Honor, I don't believe that the record supports that conclusion, especially because the jury was actually given a redacted indictment and not actually required to find what the Fifth Amendment required the jury to find, which was that line, that the total income line, line 22 on most of these tax returns, was in fact literally
Well,
false.
was were lines 7 through 21 literally true?
Your Honor, they were not charged, but to
Were
answer
they,
that-
they weren't true, were they? That was the fraudulent part.
Our position, Your Honor, we would dispute that, but to answer the court's question, all the jury was required to find was that the total income line was false. And to answer this court's question, Your Honor, as to whether the other lines, essentially the baked-in numbers, were literally true, the court would have to look at, and the jury would have to look at partnership tax returns and other aspects of 1065.
I mean, it just seems to me like you're saying line 22 is literally true because the math is accurate. You're saying 2 plus 2 literally equals 4. But if if the 2 and the other 2 are fraudulent, then it can't be true. The whole thing is not true.
Your Honor, I believe that based on the language of the form, which is what controls, that's true with this court's precedent in Baer and Good and Sarwari, then based on the language of the form, the government could have charged Mr. Cohn with line 7 or line 12 or line 14, whatever it may be.
The court charged him with 7206 subsection 2.
Correct, Your Honor.
And it's a very broad provision. It includes all of what you're talking about, but the point is the form did not call for a fraudulent entry. It called for a truthful entry of business expenses supported as the tax code requires.
In Your Honor, I appreciate where the court's coming from, and I'm going to pivot to a different issue, but as a practical matter, all I would say and all I would respectfully push back on is that under the Fifth Amendment grand jury clause, what's actually alleged in the indictment shouldn't shift. So in other words, if line 22 is what's alleged in the indictment, the jury shouldn't be allowed to convict on line 7 or line 12. The threshold issue before this court, though, is whether there was authority to prosecute in the first place. 28 CFR .70 expressly stated that criminal prosecutions shall be supervised by the Assistant Attorney General of the Tax Division. That undisputedly did not happen here. There was no Assistant Attorney General properly nominated and confirmed by the Senate pursuant to Article 2, Section 2 of the Constitution. We commonly call it the Appointments Clause.
Take me factually through the facts. I had a little trouble. I did dig out, I think, the facts on this, but you can start with the fact that the Attorney General under Section 510 is given a delegation authority, and that in this case, there's a document from the Attorney General delegating responsibility for the tax codes to various people and acting at AAG in tax, and there's one from the AAG in tax delegating it to Goldberg, and Goldberg signing the authorization. Now, I don't know where there's a missed link there that you think there is, but it seems to me the record is pretty clear on this.
Two responses, Your Honor. First of all, as a practical matter, .70 we believe is non-delegable, and that's a CFR regulation that expressly gave the authority to a principal officer, to the Assistant Attorney
Hold
General.
it. Let's go back to more fundamentals. 510 gives the Attorney General the authority, right, to delegate. You're not arguing if Section 510 is unconstitutional, are you?
No, Your Honor, I'm not.
Okay. 510 gives the Attorney General the right to delegate. And the attorney, then there is a document in there where the Attorney General at the time delegated the responsibility to the AAG, this Assistant Attorney General in tax, the responsibility, acting Assistant Attorney General. And there's a document where he appoints the DAAG for tax, which would happen to be Goldberg, and Goldberg then signed the authorization.
The constitutional problem there, Your Honor, is that to the extent that this court were to interpret, I believe it was acting tax assistant attorney general John DeSico's delegation, so to speak, as a permanent delegation, which is the only way to interpret it. There hasn't been an assistant attorney general properly nominated and confirmed by the Senate since Kathy Keneally left in June of 2014.
The authority was granted to the Attorney General legally, correct?
Congress granted the authority to the attorney general. However,
All right, now that's not an appointments problem. Now we're within the Department of Justice, and there's nothing with the appointments problem. Now, the Attorney General then made a delegation in this case, and he made it with the authority to the acting Attorney General in charge of tax. Now, that's not an improper delegation, is it?
the problem, Your Honor, is that under
I said, is that an improper delegation?
it's not an improper delegation
Okay.
from the attorney general
To the AAG, right?
to the acting AAG.
Right. Now, the acting AAG made a delegation to DAAG Goldberg, right?
Yes, Your Honor. However,
Okay, was that unauthorized?
I believe that that was unconstitutional because it takes it creates a permanent delegation to a non-presidentially nominated Senate confirmed office holder, which
There's nothing in 510 that says you have to be, a delegation has to be to a confirmed person. The only person level confirmed is the Assistant Attorney Generals. After that, delegation goes down to the Deputy Assistant Attorney General and others, and they're not confirmed by the Senate. It's this operation is so big, they have to delegate. And they did delegate, and they carefully delegated here.
You're under the Fort Stewart case, and I say my time is up, but if I may answer the court's question.
Yes, of course.
Under the Fort Stewart case, agencies have to follow their own regulations, and that's what's missing from, I believe, Your Honor's analysis, if I could respectfully push back there. Because as a practical matter, there's a mandatory supervision authority, Directive 128, to the extent that this court even considers that having any sort of legal significance in this analysis. The Department of Justice in this case didn't even follow as it applies to approval of search warrants, I'm sorry, of grand jury subpoenas, as it applies to this
That's a
delegation.
new argument, right? That wasn't raised in your below or in the opening.
We did, Your Honor, raise it in the reply brief in
Right.
response to an argument made. I
Right,
don't
so
believe,
New argument.
I would respectfully say that it's a continuation of essentially responding to whether
That's not,
or
it's a totally different problem to say that they didn't get the subpoenas correctly.
And that's
Right?
not even the
In
prosecution.
some of these directives, certain authority is reserved to the AAG and other authority is delegated to the DAG. And
Yes, Your Honor,
I mean, you can't lump it all together.
Well, Your Honor, what I'm saying, and I appreciate where the court's coming from, is that to the extent that the government is using Directive 128 as the magic bullet that essentially justifies everything they've done here constitutionally, they haven't even followed Directive
They
128.
did. They delegated the authority to prosecute attorneys for taxes to the DAAG. And they reserved, the AAG reserved the right to subpoena attorneys, which is a different problem. We have a prosecution here, and the prosecution of attorneys was delegated.
Your Honor, there's two different powers. There's an added layer of prosecuting attorneys, but there's a consistent non-delegable power to supervise that is not delegable by the AAG of tax to prosecute anybody for a tax crime. And that's where the distinction with a difference occurs here. If I
All
may,
right, yeah.
I see that I'm in time. Thank you, Your Honor.
Yeah, we'll hear from Mr. Dickhouse.
Thank you, Your Honors, and may it please the court. Carl Dickhouse, I represent, to your question, Judge Niemeyer, Liza Cholet.
Cholet,
Yes.
a French pronunciation. Maybe?
St. Louis is home to all the French and Germans, so it makes it hard to know how to pronounce anything. But
Well,
yes.
the Germans would pronounce the T, for sure.
Exactly. It is a French name. And I want to address perhaps one of the more critical issues with regard to Ms. Cholet, which is the lack of venue. And specifically, in 98 and 99, the U.S. Supreme Court decided the Cabrales case and the Rodriguez-Moreno case. And this court shortly thereafter decided the Bowens case, where you held that consistent with the Supreme Court's rulings, you had to look at the essential conduct elements of the alleged crime, which you got by looking at the verbs that define the crime, if it were not defined in terms of effect, which 7602 is defined in terms of the actions taken, not the effects of those actions. And that the government was then required to prove by preponderance of the evidence that those actions took place in the Western District of North Carolina, wherever the trial was done. Here, there is no evidence offered by the government at trial about the essential conduct elements or their occurrence.
Well, let me ask you this. I understand your whole argument, and I've looked at the statute, and the statute talks about anyone who procures or advises the preparation or presentation of any matter relating to the taxes, but the key word would be procures information for preparing the tax returns. And it seemed to me that the evidence showed that Mr. Simmons or Ms. Cholet procured information from their clients in North Carolina to prepare tax returns. And why wouldn't that be an element, a conduct element there?
Well, there's two things, if I may, Your Honor. I mean, it's a good question. The first is that there was no procuring done by Ms. Cholet, and this is not charged as a Pinkerton conspiracy. It's just a single substantive count.
No, I'm talking about
But
Ms.
she did
Cholet
not.
got
Ms.
it from
Cholet did not
Simmons, right?
procure. Any procurement that she did took place in the Eastern District of Missouri. There's no allegation she went to North Carolina to do it. The second argument with Mr. Simmons.
Didn't she get the information through Mr. Simmons?
It's true that Mr. Simmons' office would gather information from Mr.
Yeah.
Simmons' clients and then
And
furnish
provide-
it to the
and
Cone
provide
Partnership.
those to Ms. Cholet, right?
Well, to the Cone Partnership. Again, the Bowens analysis
And where was Mr. Simmons' office?
in the Western District of North Carolina.
Right.
I'm not disputing that. But under the Bowens analysis, the government is required to prove for each count as to each defendant. What the government did was say generally, some information came through North Carolina.
The information were all the tax persons involved, there are four of them, one from Minnesota, but that information still came through Mr. Simmons, and then the other three from Western North Carolina.
And
that
then the
came through
LEPRA-
Mr. Pardon me?
The Alepra returns were from Missouri, but, and
Well,
Novak was
the
from.
information was procured in order to prepare the tax returns in Missouri. And the statute is very broad, and it doesn't even have to relate to a tax return. It can even just relate to tax matters.
And
Arising under, in connection with, or arising under the tax matters. And it seems to me that it's pretty clear that the information was procured from Western North Carolina through Mr. Simmons' office.
And I do understand that. I mean, it's not clear for each count. Obviously, Ms. Cholet did not prepare the returns in each count. The government concedes as much. She prepared 7 of the Forms 1040. And there was no evidence that she caused this information to be sent from the Western District of North Carolina. There just was no evidence. The government presented no evidence on this. So while it may be reasonable to infer that, the balance structure has a two-part
Wasn't there
test.
also some evidence, at least as to the clients who lived in the Western District? I thought there was evidence that the Cone Partnership made sure that the clients had an opportunity to look at their returns before they were filed, right? So the returns are sent to the client and they get to review them.
That's correct. And I believe under the
As
Sterling
part of-
decision.
Part of assisting in the preparation, perhaps, of the filing.
Well, under the Sterling decision, the preparatory acts. That's not an essential conduct element.
Preparatory
It's-
to elements, but in this case, the preparatory acts are an element of the offense. Procuring information relating to a tax return is part of the offense, whereas preparation is before there's an element involved. And in this case, not only were the returns reviewed by the proposed returns proposed, but there were also the partnership agreements were in North Carolina, right? Registered in North Carolina?
The partnership agreements were registered in Raleigh, which is in the Eastern District, so that wouldn't, and a partnership return, whether it's registered or not, has nothing to do with the preparation of a tax return. I mean, it's related in the conspiracy count.
No,
but-
it's really, it only has to be in connection with any matter arising under the laws. And that whole scheme was part of the preparation of the tax return. The GE, what do you call it, GEP?
The gain elimination plan, the
Yeah, yeah,
GEP.
yeah.
I understand, but the GEP, first, that was for the preparation of an uncharged tax return, the 1065 partnership returns. The 1065 partnership returns are summarized, placed on a Form K-1. The Form K-1 is then provided to the preparer of the 1040. The preparer of the 1040, looking at the K-1, cannot tell anything about the uncharged partnership returns. That's the first thing. And the second thing is that in looking at the essential conduct elements and the evidence required for each proof, they made general allegations, which of course would be impossible to refute. They did not demonstrate
But you don't go to the
how she
allegation.
did this.
For the venue, you go to the elements of the offense, don't you?
It's a two-pronged test that must be done under Bounds and Sterling and Mosby. You have to, you go to the elements of the offense, you take out those verbs, which is the aiding, abetting, preparing, procuring, and it doesn't say procuring information, it says procuring a tax return. Procuring modifies tax return. And then, once you've determined the elements, you say, where were those committed? Who committed them and where were they committed? Everything that was done by Ms. Cholet was done in the Eastern District of Missouri. Nothing was done in the Western District of North Carolina. And then you have to establish that by preponderance for each count. And here, no effort was made. If you look at Sterling, if you look at Mosby, they found venue on certain counts and not on other counts. That could not be done here because no evidence was presented. I see my time
Yeah, it is.
is up, but thank you, Your Honor.
Yes, sir. Mr. Allenwood?
Thank you. May it please the court. Todd Ellenwood for the government. Given the questions from the bench, I'm actually not sure where to start because you did my job for me. I will start with venue.
Well, these are questions, these are not conclusions.
I understand,
And,
Your
we
Honor.
are pressing them on areas where we think there needs to be answers, but.
And if there are areas that you have, I would start with venue. The evidence was overwhelming. There are specific documents as to each and every count. That they weren't spelled out in closing argument or some such is immaterial. The jury instruction, which was not objected to below or raised on appeal, for counts 2 through 22, you must decide whether an act was committed by a defendant or caused to be committed in furtherance of the preparation of filing of the false tax return at issue. It includes some examples, one of which is whether a tax return was signed in the Western District. 5 of the returns were signed in the district. This was at a time period where most tax returns are electronically filed, but there are 5 that are signed with a wet ink signature by 3 of them are Mr. Simmons. He lived and worked in the Western District of North Carolina. They were signed by his wife on the same date. That's dispositive evidence as to those. Mr. Bowers was an older gentleman who operated a pharmacy in Jefferson, North Carolina. The evidence showed that if he needed to have printer paper put in, it was going to be Brandy Davis from Mr. Simmons' shop coming over and doing it. It was very, very hands-on care. For example, and in terms of even if the allegation is that the defendants, in order to have venue in the district, would have had to reach in and request the information, we have that evidence. Ms. Cholet emailed Brandy At the time of trial, she was Davis. In the documents, she's Ms. Marlowe. But Ms. Davis, she says to her, "I've sent out reminders to almost everyone about 2017 tax info. I think the only ones I need your help with are Greg Bauer." That's the pharmacist. Ms. Davis responds to Ms. Cholet, "Here are Shane's in the agency." Shane is Mr. Simmons, so she's sending the information for Mr. Simmons. "I couldn't remember if I'd sent it or not. I'm picking Greg Bauer's up this afternoon, so I will get it over to you this morning." That's at JA 6114. There were over 1,000 exhibits entered into evidence. If you asked me for a specific count, I could tell you what specific document establishes venue. As to the argument for the appointments clause, it fails at every level. The first one is whether 0.70 even requires authorization of tax returns. The language is, "The following functions are assigned to and shall be conducted, handled, or supervised by the Assistant Attorney General Tax Division," and it has, the first one I think is civil tax, and then B, criminal proceedings arising under the Internal Revenue laws. I would almost think with my opponent's argument, you'd almost be better saying that the AAG is required to conduct and handle every single tax matter in the United States. At least those words are in there. But what I really want to point you to is every single regulation for an Assistant Attorney General in the Department of Justice has the identical language. Just scratch out tax and write in criminal, for example. So for the criminal division's regulation, which is at 0.55, it says that the following functions are assigned to and shall be conducted, handled, or supervised by the Assistant Attorney General Criminal Division, and then it lists all kinds of things, including criminal frauds against the United States, all criminal and civil litigation under the Controlled Substances Act, all immigration. No one has ever alleged that the head of the criminal division has to individually authorize every single drug case. So I don't think that I'm arguing that 0.70 doesn't even require this specific function. If it does, it's delegable. The defendants have made no effort to explain or distinguish House. It's black letter law. Every court that has looked at this has said and approved broad delegation of authority. There's nothing about the statute. There's nothing about the initial statute, as Judge Niemeyer talked about, or the regulation itself that limit delegation.
Can I ask you about an issue opposing counsel didn't get a chance to address yet, but why was it not overly prejudicial to admit evidence of Mr. Cohn's prior tax fraud conviction in a tax fraud trial?
Okay, so it was alleged in the indictment because it was part of the fraud structure, that either clients asked about it. If you Google his name, it's the second or third thing that pops up. So either clients would ask about it, or sometimes he would lead with it. He would lead. So sometimes there's a sword and a shield quality to this. Oh, what was in the indictment was this and that, and the government railroaded me. But sometimes it would be more of a sword. Look what I'm willing to do for my clients. So the district court was very careful about this and restricted our use to it to only the things that were false statements that he made, and that we were allowed to get in portions of the indictment through a stipulation that pertained to the specific lies. And so that was carefully limited, and that was a
But it's in some ways in part of his scheme. I mean, he used it, so the government would have to, at least in part, talk about that prior tax fraud conviction to tell the story.
Yes. And as an example of that, Your Honor, it's direct evidence of willfulness. It's very, some of it is very extreme and is basically, I will not flip on you. It's not even, hey, nothing to see here. In the undercover recording, he says, the undercover says, hey, have you had any trouble with the IRS? Like, this is an interesting tax shelter. Have they questioned it? Mr. Cohn, quote, "The only thing you need to know is that I'm fiercely loyal to my clients. And I had a situation about 20 years ago." And then he goes on to provide false statements about it.
Did he stipulate to the admission of
So,
this?
yes, our arguments are two. We have the one argument that by opening it, and that's a strategic decision, that by opening with it, the door is
Well, it's
open.
charged conduct as part of the marketing of his GEP.
Right.
You're getting, yep, there are 5 different levels on this. I would say he opened with it.
But the court had already ruled against him when he opened with it, right?
Well, but that's consistent with Oler, is that if Oler stands for the proposition that if a district court judge rules against you, even if it's wrong, you make the strategic decision if you enter the evidence. The difference here is that Oler was about entering the evidence. So if somebody was on the stand and you ask the question, that clearly opens the door and you waive the argument on appeal. The difference here is that opening statement is obviously not evidence.
Right.
But 3 circuits have said it's the same thing. You can waive lots of things, an
You have-
opening argument.
Probably have better arguments, though, than this one.
Yep, right. And then the other one was the stipulation, that by stipulating to it, it was an effort to minimize the damage, and it did so. It's not even 404B evidence because it's intrinsic. It was actually part of the charged offense, and there's nothing about it being inappropriately smuggled in, or there's no accusation of that, oh, you just reached back and grabbed this old thing and threw it into the indictment. It's squarely part of the scheme to sell the gain elimination plan. And we had at least two clients testify about it and the undercover. There was plentiful evidence as to that one. And then we haven't even gotten to I think I've covered 2 of the prongs that fail for the appointments clause argument, but a defendant in this position has to show prejudice. And a lot of the courts, district courts, that's what they start with first. I was actually surprised with how little law I found on this. And a lot of district court judges just start with that. They'll say, like, well, under Costello, a grand jury indicted, and that's enough for it to go to the court. So you haven't shown prejudice, and that's the end of the analysis. Here, the district court judge wanted to be really, really careful, and at the initial hearing, I pushed back on providing lots of our internal materials. We ultimately provided the transmittal form, the actual internal authorization forms for Mr. Hubbard and Mr. Goldberg. So the record was quite fulsome on that. We pushed back and filed it under seal. It eventually was, portions of it were unsealed. There's no argument that been made that there's real prejudice here. There is some confusion kind of in the law that sometimes the structural cases do sound like they are very all-inclusive, but those are virtually all about judicial officers. I made this argument more fulsomely. I hope you had a chance to read, or do have a chance to read, the government's bail opposition. And the reason why that's relevant is that some of the cases that came up afterwards related to the U.S. Attorney's offices were not part of our briefing, and so I was able to respond to it in that. But I also responded to some of these other arguments more in more fulsome detail, and whether it is if the adjudicator is improperly authorized. So in the Supreme Court cases, it's ALJs or members of the Coast Guard Court of Review. If it's the adjudicator, that is structural error. That's fundamentally different than here, where a grand jury indicted, the case went in front of a district court judge with jurisdiction, and a jury convicted. There is no prejudice.
All right, anything further?
If you don't have any questions, no, Your Honor.
All right, thank you. All right, we have some rebuttal. We start with, I guess, to Mr. Gelfand.
Thank you, Your Honor. May it please the court. I want to start where the court questioned Mr. Ellenwood, and that's as to the prior criminal conviction. And I wanted to raise 3 specific points to that. Number 1, there's no question that this brought into trial a similar offense, a prior Title 26 criminal tax conviction from 2002. This court's precedent in Hernandez-Sanders, district court precedent in Chin, basically says that should be introduced sparingly, if at all. And
Yeah, but you're talking about a 404B type of analysis. This is a case where there was charged misrepresentations made to sell the program, and that he lied about his earlier prosecution. It seems to me, I don't even know why it's an issue in the case myself, based on the charges and the evidence in support of those charges.
It's an issue because we raised this in documents 135 and 283 at the district court level, essentially in motions in limine. And the reason why, Your Honor, is because the district court basically said this is only admissible to establish evidence of quote-unquote lulling. I was convicted of a crime, I got your back, those kinds
Well,
of
sure,
things.
but that's evidence, and if the court admitted it for that purpose, that's fine. But the point is that it is part of the charged conduct.
Over our objection, we moved at every possible stage, but
Well,
Your Honor.
of course, but you would object to every charge. I mean, the charge in this case was that he lied about the scheme and seduced clients, customers, and there's actual testimony to that effect. I mean,
Here's the problem, Your Honor. The only witnesses questioned about this were Rose, Bear, and Damian Novak. Not a single one of them testified to lulling. So the government has continued, even on appeal, to say that's what it's admissible for. That's why it's in the indictment. Not a single one of
Didn't
those
they say things like,
witnesses.
it gave me some comfort, or it reassured me? I don't know. They used words that, to me, sounded a lot like lulling.
Not, Your Honor, through the typical lulling. I was trial counsel on the case. I was
But did
candidly-
they testify in the way that Judge Rushing just recounted, that they felt comforted by him saying he's fiercely loyal to his
Not-
clients?
Not tied to the criminal conviction, Your Honor, and to the 2002 conviction. And I would
But
specifically.
tied to his misstatements about it.
Not tied to any misstatements about it, Your Honor. I would specifically, I know I'm out of time, but I would direct the court's attention to our opening brief when we actually go through Rose, Bear, and Novak's testimony. We cite specifically to the record in the joint appendix. Their testimony is clear that it doesn't actually do what the government characterizes them as doing.
okay, thank you.
Thank you, Your Honor.
All right. Mr. Dickhouse?
Thank you, Your Honor. One quick thing with regard to the venue argument is that the Cabrales decision specifically, and this was adopted by Sterling, focused on where the conduct was done. It says venue may, essential acts may have happened, but where was the criminal act done? So where did Cholet, who's the person charged with the act, do the procuring? In the Eastern District of Missouri. Never, never in the Western District. In fact, there was no evidence. There was some testimony that she had once visited on an unrelated matter, but no evidence that she'd ever done anything in the Western District of North Carolina. And the second part that's related to this, which I didn't address in the initial part with regard to the conspiracy, was when they charged the conspiracy, Cholet was not even a tax attorney until 2013, well after it had begun, and did not appear on any of the tax returns that were charged until 2016. Initially, when it was indicted, the government alleged that she had joined into an agreement, although no evidence was produced on this at trial, to market an illegal plan, the gain elimination plan. However, at trial, the government's own expert witness said gain elimination plans are not per se illegal, but the plans charged here were improper. So there was no proof that she ever agreed to commit an illegal act in the implementation, which was the change strategy, which is why we argue that the indictment was amended and the basis on which she could be convicted expanded beyond the Fifth Amendment's grand jury clause. And in addition to that, and as the government proudly crowed to trial, she had a gain elimination plan herself. It was never civilly challenged. No deduction was ever disallowed. It was not criminally charged. It had a signed partnership agreement. In other words, the evidence
But that's just
suggested.
arguing the evidence. In other words, the structure of the tax plan might have been upheld as an appropriate shelter if it had economic substance. But this one, the government didn't challenge the structure. They challenged the economic substance of the plan because there were no services provided, there's no intellectual property provided, there's no cash changed hands, no payments made. They were all fictional, and that was the problem with these particular terms. Now, she used the same structure for something. Maybe she had legitimate payments. But the government's position isn't that the structure was wrong. The government's argument is that it was all made up.
Well, the government's argument on indictment was that the structure was wrong. The government's argument going into trial was that the structure was wrong. When their witness testified, oh no, the structure itself isn't wrong, they pivoted, which to me represents an issue because it's an expansion of the basis of appeal. And what I'm saying is they made these allegations about economic substance despite the fact that these were charitable gifts. All of the testimony established that there was insurance actually in place and in force that would guarantee that these gifts would be made to the charities and therefore that they would be entitled to deduct them. The government used a proxy witness. They used Ricketts as a proxy witness. They wouldn't allow someone from INFC or they wouldn't call somebody from INFC to testify about what INFC knew. So Ricketts was able to attribute to them things and then not be cross-examined or confronted by the defendants as to what INFC's position was.
This sounds like a new issue.
Well, no, I'm just saying,
All right.
we raised this in the briefing,
that.
that he was a proxy witness, and so there wasn't evidence to support this idea that these things weren't valid, and in fact, INFC, we were all here because they sued previous people for not making the gifts, and they won. And so all of these charitable gifts were actually made. Thank you.
Thank you, yes, sir. We'll adjourn court for the day and come down and greet counsel.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.